entrepreneurs. It's Michael Mort with Argent Place Law, the law firm for entrepreneurs. This is the fourth part of a series in which we're talking about trademarks, seeing what we can learn from this dust-up between Megan Rapinoe and Dwayne Johnson. They use similar marks. Rapinoe used hers first, and she's claiming that the XFL's mark is total ripoff of her mark. Well, we'll use this as an opportunity to delve into some details of trademark applications and how the government responds to those applications. So let's get right to it. First, just a quick review of what I presented in previous sessions. We talked about the importance of trademarks, why you want them, how they protect not only companies, but consumers. Then we did a basic trademark search and we learned some tricks to try to find who owns a famous mark and what other trademarks does that company own or has applied for. And lastly, we worked through that trademark application and got a basic understanding of that trademark page. And now we're going to jump into what happens when an office action is issued. Something's wrong with the application, and let's see how the trademark office presents that. Okay, here's what we're going to talk about. We're going to look at the trademark search and document retrieval page and get a summary of what goes on. And then we're going to dive into the document section of that because there's an office action on one of these trademark applications. That means the trademark office found one or more things that they found objectionable that they need to have fixed. I want to mention what's called a 2D refusal. There's a specimen refusal in this application, something that needs to be fixed in the identification of goods and services. Also, what about the mark description, just a description of the mark itself. And I want to mention something about the time to reply to any office action. So let's jump to the trademark office website. Okay, I'm going to quickly jump through this because we've done it a couple times now. By now you should remember that you go to uspto.gov up in the URL browser bar. By now you should remember that you go to up here to the uspto.gov and then hover over trademarks and then searching trademarks online and then hit the link to the trademark electronic search system, which then takes you to this page, and we hit the basic word mark search. And then you may recall that the owner of the mark in question, the X, is AXM LLC, Rapinoe's company, is the owner. So we select owner here and then submit query, and it brings us to this page, and this is the mark that we're interested in, the X. This is the basic trademark page that we discussed earlier, and I want to point you to TSDR. We got all the information we wanted to glean off of this page. We want to go into the trademark search and document retrieval system. So click on TSDR here, this blue button, and that takes you to this. Has two tabs, status and documents. In the status page, a more detailed summary of what we already saw on the previous page, but a little bit more detail about mark and the current owner information, etc. But what I'm really interested in is what about the documents, because trademark applications are completely public. So you can see everything that's going on in the journey of this becoming from an application to a true mark. Click on this tab here, documents section, and we can see here that the trademark application, the drawing of the mark, and the specimen, an example of use in commerce, were all submitted on September 16th, 2021. And then almost exactly 3 months later, a search was done, what they call X-search summary. And that same day, the trademark examining attorney that performed the trademark search issued an office action. That's what we want to learn from today. So click on the link that says office action outgoing. And it brings us to this document. It'll actually appear in a new tab in your browser. At the top, it shows that an email was sent, AXM LLC, and actually contact information for the lawyer that filed the trademark application, some other details here. And I want to get down to this section down here, trademark office action. This says it's a non-final office action. That means that there's time to respond. When there's a final office action, if you don't respond satisfactorily to the final office action, then the trademark is permanently refused. Now, there's a lot to look at here. This date is important. It was issued on December 17th, 2021, and bottom of this, we'll see that the applicant has 6 months to respond to this. So a response will be due on June 17th, 2022. This mentions that the examining attorneys attempted to contact the applicant, but there was no response. So the office action was issued, and the applicant now must respond in writing. The first item is always whether or not this trademark application conflicts with another trademark either applied for or already in use. This is what's called a Section 2D search result. The trademark examining attorney looked for other trademark applications and existing trademarks, issued trademarks that might conflict with this mark. In this case, the examining attorney found no pending or issued registered marks that would conflict with this. If you get this kind of office action, it says that there are conflicting marks. It's very difficult. It's not impossible, but it's very difficult to overcome. They have to argue the law and fact with the trademark examining attorney to see if they can get their decision overturned. But in this case, we don't have any conflicts, so we move on. But there are 4 other items that have to be addressed. And here's a summary of those issues. There's a refusal of some of the specimens. There's an amendment has to be made to the identification of services. The trademark examining attorney has an issue with multiple classes, and this is a result of a maybe a typographical error, a very small error in the original application. And then there's a description of the mark the examining attorney wants the applicant to amend. So let's get into what each of these items refer to. This first issue refuses some of the specimens, and this applies only to those services that are listed in classes 35 and 38. None of the other classes are affected. You may recall that this application listed multiple classes in which different services were referenced, and only the services in these 2 classes, 035 and 038, are affected by this refusal. Trademark examining attorney says specimen does not show direct association between the marks and the services. When you read all of this, you understand that there has to be a good link between the mark and actually what is listed for the services that are provided. Here's a good statement for understanding. When determining whether a mark is used in connection with the services in the application, the key consideration is the perception of the user. That would be the public. Would the public actually understand the relationship of this trademark to the services that are listed in the application? So you have to supply a specimen of your advertising or promotional materials that show this direct association. That's what the specimen does. It shows a direct association between your mark that you're applying for and the services that you're promoting. To show a direct association, the specimens consisting of advertising or promotional materials must do 2 things: explicitly reference the services and show that the mark is used to identify those services and the source being this company. Finally, about this specific issue, I mentioned that there was apparently a misplaced semicolon. This is how important punctuation here is. Notice the sentence. Finally, the wording publication of magazines concerning sports, news, popular culture, health issues and fitness, beauty, wellness, cosmetics, and exercise products. Notice that all of these things are separated by commas, except right here between fitness and beauty, there's a semicolon. That means in an application, semicolon means a new set of services. Everything after that would be a different set of services. So that's the examining attorney took that literally and said these are different services. Beauty, wellness, cosmetics, and exercise product would be a different set of, actually in this case, products, and don't belong in this class and shouldn't be in this list. But the examining attorney recognized that if you meant to have a comma instead of a semicolon, then they should amend this part of the application right here where this semicolon appears. The next issue, multiple class application requirements down here, refers back to this issue of the semicolon. If that semicolon was desired, then beauty, wellness, cosmetics, and exercise products would fall into a different class, and that gives rise to this part of the office section, multiple class application requirements. Jumping down to that section, the examining attorney proceeds as if the semicolon up in the previous section was actually desired, and then that would give rise to products in a different class, and that those specific classes were not mentioned and no specimens were provided for those classes. So this lists what the requirements are to go ahead and provide those additional specimens. Notice the trademark office is forgiving up to a point where you actually have to supply specimens for goods or services that are mentioned but haven't gotten specimens specimens yet. But notice that when you supply specimens that you forgot or left out in the original application, you must submit a verified statement that the specimen was in use in commerce in connection with the goods and services in the application at least as early as the filing date of the application. Finally, examining attorney took issue with the mark description itself. Again, this is an example where the mark description was deficient, but the examining attorney gives a suggested mark description. It's not required that this be used, but this can be adopted as a mark description because it was recommended by the examining attorney. The original mark description was merely stated that the mark consists of a stylized letter X. The examining attorney suggested that this following phrase be added, shaded on the left side. Mind you, the appearance of the mark itself is what's important, but the accurate description of the mark is required in order to be able to do a search in a graphical way on what this mark actually looks like. That's it. Those are all the issues. Then the examining attorney mentions how one is supposed to respond. There's a link provided, and it mentions again at the bottom that missing the response deadline will cause the application to be abandoned. So you actually have to respond within the time stated at the top of this letter. Scrolling back to the top, we see that the USPTO must receive applicants' response to this letter within 6 months of the issue date, and that was the December 17th issue. That's it. That's about all I wanted to get out of this particular application. There are many different types of things that the examining attorney could take issue with, but this is a pretty good summary of some of the things that can go wrong. But don't worry, all of these issues can be cleaned up without too much effort by a knowledgeable attorney helping out the applicant or by the applicant themselves. So that does it for this final session of this series of articles about using the dust-up between Megan Rapinoe's trademark application and Dwayne Johnson's trademark application. In this final video, we talked about what a 2D refusal is, what a specimen refusal looks like, and how that might be fixed up, how to identify the identification of goods and services must comply with the requirements of a trademark application. There's a slight issue with mark description and discussing the time to reply. This series of videos has been provided by Argent Place Law, the law firm for entrepreneurs, where our vision is that there should be a successful entrepreneur in every household. We firmly believe that entrepreneurs are going to save the world, and Argent Place wants to support you in doing that. Send us an email at SaveTheWorld@argentplacelaw.com. We'd love to hear from you. Thanks for watching this series.